And as is with some great sadness that I follow on from Senator Carr, particularly on the final words he put onto the Hansard in the chamber today, and that is that the government is holding children to ransom in order to get agreement on this bill. And I have to say that I agree wholeheartedly with Senator Carr's comments. And in looking at the bill before us today and going by the media reports, because that's all we do have to go for, seemingly what some in this place have signed up for is no guarantee. And if the media reports are correct, in exchange for increasing the humanitarian intake, which is one of the propositions we believe has been put forward, that offer to increase the humanitarian intake is a conditional one. So it seems that those senators in this place that have signed up to that deal don't even have a firm undertaking, not a firm undertaking, just a vague commitment that if others are processed, they might find a way to increase the humanitarian intake. And Senator Carr is completely right when he says the government could act on children in detention right now, and it could. And many of the government senators and members have had a group called Love Makes a Way come and talk to them, sit in their offices, a religious group that has said over and over again that what the Abbott government is doing to children in detention is wrong. And those children could be taken out today, yesterday, a month ago. But no, we just see not an ounce of compassion from the Abbott government in relation to this. And equally, people could be processed. And what we've seen over and over again from this government is the complete demonisation of refugees and asylum seekers in our country, and for those who seek our protection, we've just seen nothing but demonisation. And of course, Madam Acting Deputy President, the bill before us today is really about a much bigger issue, one that the Abbott government is completely silent on. And all we see from the Abbott government is their mean spirit and their small-mindedness, not just in the area of refugees and asylum seekers, but right across all areas of government. That is what we see. Because, Madam Acting Deputy President, we never hear the Abbott government talk about refugees who are displaced from their home country. They never talk about that. And they certainly never talk about the prosecution of refugees. And they never acknowledge that the prosecution and the persecution of refugees is a worldwide issue. We never ever hear the Abbott government talking about that. And that, Madam Acting Deputy President, is really where the debate should start. It should look at the global issue facing all countries in the world. But no, the Abbott government, because of its mean spirit, because of its demonisation, wants to start at those who try to enter this country. That's where they want to start. It's as if they were just beamed in and that's where they start from. And so what I want to do and what others want to do is to shine a light on the Abbott government's absolute unwillingness to take that global perspective on refugees. And instead, over and over again, it seeks to make political capital, and over the last couple of days it sunk to its lowest level by making political capital out of children. And it is making political capital out of those who are genuinely seeking asylum. But the Abbott government has shown no compassion on the issue of refugees. Instead, it demonised refugees and asylum seekers at every opportunity. And if we think back to a few months ago, On the death of Reza Barati, the minister was the first to point the finger for Reza's death was somehow at the fault of refugees. Those were the first words he uttered. Somehow they were at fault because they were rioting. And of all of the questions, from government backbenchers, whether in the other place or in the Senate, from government backbenchers to the ministers, are about stopping the boats. They're not about the world's global refugee issue. They're not about the world's global asylum issue. They are simply about stopping the boats and calling asylum seekers illegal maritime arrivals, dehumanising them. Not one question by a government backbencher about children in detention showing any skerrick of humanity. Not one question about the global refugee solution. Just this continued hardline demonisation of refugees and those seeking asylum. And this bill before us today seeks to make it easier for the government to deny its protection obligations, and it does have obligations, to certain people. And of course, there are a lot of myths, and I heard them in this chamber yesterday at the start of this debate. I heard a lot of the myths yesterday. And the facts are, Australia does not host a large number of refugees. By comparison, Pakistan, a country that doesn't have the wealth that Australia has, hosts over 1.6 million refugees. Iran hosts almost 900,000 refugees. Chad, almost 500,000. And Australia, just 13,750 refugees granted permanency residency by Australia each year, a tiny, tiny drop in the ocean. Per $1 billion of GDP, we take in less than 35 refugees. By comparison, Pakistan, 281. So I would say that we can afford it. And when we look at refugees hosted by countries across the world, Pakistan is the #1 country, and that stands to reason because they are in the conflict zone. But to suggest there's some kind of queue or orderly processing, of course there isn't. And that is another myth, another way for the Abbott government to dehumanise refugees and asylum seekers. And on that refugee hosting list, Australia is number 49. Number 49 down that list. And countries ahead of us include China, Ethiopia, United States, Jordan, Lebanon, Iran, and on it goes. We are not a fair country, a generous country when it comes to refugees and asylum seekers, and this bill today seeks to curtail rights, and it seeks to endorse in a legal framework the sorts of actions we've seen the Abbott government taking on the high seas, of being able to turn boats around, of trying to separate out a boat and its occupants, all of this sneaky kind of stuff to legitimise what they have been doing in secret, and trying to legitimise that. And when we look at asylum applications, where does Australia sit? Well, on the list it's number 30. So up the top of the list is Lebanon, then Jordan, then Turkey, then Iraq, then Egypt, then Germany, then France, then South Africa, Sweden, United States, all in the top 10. And where are we? Right down the list at number 30. And of course, we are not swamped with applications. There is no need for this harsh, cruel legislation, because the reality is we are not swamped by refugee applications. Quite contrary to what you would think the Abbott government would have us believe. But that's the truth of it. We are not swamped. Compared to other refugee hosting countries, Australia actually receives a very small number of asylum applications, with about 16,000 people seeking asylum in Australia. By contrast, the United States receives 68,000 applications a year. Germany, many more, almost double than that, almost 750,000. And Australia has an obligation to the global refugee situation, and our responsibilities don't start and end with boats. They clearly do not. And so this legislation before us today will seek to further demonise those genuine refugees seeking asylum in our country, and it will curtail their rights, and it is done off the back of blackmail. It is done off the back of blackmail. This commitment to state that we will take children out of detention by Christmas, I mean, that's a furphy, because the government has been so slow at processing applications. We would have no guarantee of that anyway. There would be no guarantee of that. So I don't know what senators in this place think they are signing up to when they sign on the bottom line that somehow children will be magically out of detention by Christmas time. We're going to see yet a new form of visa, a Christmas visa issued to those children in detention, because we already know that it's taking the Abbott government months and months and months to process applications. So why would any senator in this place think that somehow, magically, the government is going to process those children in a matter of a couple of weeks? Who in their right mind would believe that, particularly from a government who has constantly broken promise after promise? And how could you be hoodwinked about the increased numbers for humanitarian reasons when it is conditional upon the government doing other sort of processing what it claims is some kind of legacy? Well, it's been the government for more than a year, and all we've seen it do is really almost stop processing claims in this country, because they are well and truly below any kind of rate that we've seen in the past. So why would we even think that our humanitarian intake would be increased when it's a conditional commitment on the basis that the Abbott government processes 30,000 other applications? Whoever did the negotiation is a very poor negotiator, to think we could get to that number and to think that we could have children out of detention by Christmas. And in any event, it's such a low blow. It's almost the worst thing the Abbott government has done, is to hold children up as some kind of bargaining chip. So we do process very few applications in relation to other countries. And of course, we know actually that many refugees return home. But a set number of years in Australia cannot guarantee people a durable solution. And we've seen this new visa, the Chev visa. There's some question about what that might lead to. That hasn't been properly thought through. What does it actually mean? And here we are today, being held in this place until we pass this bill with very limited information around it. And the issue of temporary protection visas, Labor's views have been very clear on those. We believe that they are damaging to refugees, that they are inhumane and discriminatory. And we know that under the Howard years, that refugees on temporary protection visas were unable to apply for family reunion visas. They're not allowed to work, although we understand that the Minister is saying he'll give work rights as part of the deal, but let's see the detail of that. What is the assistance they'll be given to resettle in Australia? And they certainly won't be given any kind of stability on a temporary protection visa. No permanence. And the psychological damage of not only bringing in refugees fleeing persecution, because that's the test. When people are granted asylum, it is on the basis that they've been persecuted. That's what we're talking about here. People who cannot remain in their home countries, who have left those countries because they've been persecuted. That's who we're talking about here. Men, women and children. Let's not forget that. And let's not forget that refugees are a global problem. And Australia takes a very tiny part of that. And what we've seen this government do through its cutting back of foreign aid, and we saw the threat earlier this week that foreign aid would be cut even further. We resolve conflicts in other countries doing a whole range of things. Sometimes, yes, we have to send troops in, but we also go in there and we put aid in that talks to people and educates people about democracy. We put aid in that helps with health. We put aid in to educate children, and we put aid in to provide basic water, security and all sorts of other basic needs of countries. But what we've seen under the Abbott government is a retraction of all of that. So not only are we abrogating our responsibility in terms of the global refugee problem, but we are making matters worse by withdrawing and reducing the foreign aid that we're putting in. I mean, what kind of country are we becoming? We're just becoming a small-minded, mean-spirited country. That's what we've seen this government do across a whole range of areas, Madam Acting Deputy President. That's what we're seeing, and this bill, if it gets up today, will treat refugees and those seeking asylum in our country in a very harsh way too harsh, much harsher than what is required. But obviously the Abbott government still thinks it's on a winning vote, still thinks that somehow demonising refugees is going to win it votes. Well, they're wrong, because Australians, by and large, were quite disgusted and horrified over the death of Reza Barati. And more Australians are horrified about the numbers of children we have in detention, and they are starting to ask those questions. I mean, when you have conservative religious leaders in this country risking arrest and prosecution themselves, which is what Love Makes a Way do, something's wrong. When you not radical left-wing churches, these are ordinary, everyday Conservative churches, and leaders, the leaders of those churches, are saying to the Abbott government, you've overstepped the mark. You've overstepped the mark. And I know, as passionate as the Love Makes a Way group, because yes, they've been in my office. I invited them into my office because they don't need to stay just sitting in my office and get arrested. I invited them in, we had afternoon tea and we sat down and discussed the issues. But I know that my friends at Love Makes a Way would be quite disgusted about this blackmailing. As desperate as they are to have children out of detention, they certainly would not sign up to this sort of deal. They would not, because they understand that what we need is a humane approach to asylum seekers and those who flee their countries because of persecution. And this bill is completely unnecessary, and all it is doing is trying to legitimise those secret matters that have been occurring out in the oceans between Australia and Indonesia that the Australian public don't know anything about, but what we do know is that this bill is seeking to legitimise those actions. And it's a harsh treatment of those fleeing persecution, and to use children as political pawns in this process is an absolute disgrace, and the Abbott government will be held account to that. Thank you, Madam Acting Deputy President.
Senator Bushby.
Thank you, Madam Acting Deputy President. First of all, I'd like to thank the Senate for providing the Senate with the opportunity to consider this bill. It's a bill that really does need to be considered by the Senate this week before the Senate rises, and so I thank those who supported the Senate's decision to allow that to occur, particularly in a week where the Labor Party have conspired with the Greens to rob the Senate of any opportunity, or to minimise the opportunity that the Senate has had to consider government business this week before we went away. There are a number of other bills which also were time-dependent, which the Senate hasn't had the opportunity to be able to consider because of the games that have been played in this place this week. Now, Madam Acting Deputy President, on behalf of the government, I can indicate that if this bill is not likely to be finalised by 11 p.m. tonight, the government will move to suspend the Senate until 9 a.m. tomorrow morning. Thank you.
Senator Rice.
Thank you, Madam Acting Deputy President. I'm rising today to speak about the Migration and Maritime Powers legislation resolving the Asylum Legacy Caseload Bill 2014. It's a very long name. It's a very complicated technical name. The thing that I want to focus on is this bill is about people. It's about real people. It's about people's lives. It's about people who are suffering. It's about people who Australians care about and Australians want to see protected. I think about the people, the refugees that this is going to affect, who I've met over the last 5 months whilst I've been a senator, and the many others that I've met prior to that. But in particular, I think about a lot of the refugees I met as I was on my journey to Canberra. I travelled to Canberra through regional Victoria on a listening tour, and along the way, at every stop, I managed to meet with members of the community, and the plight and the fate of refugees, both those that were living in the community, those that were languishing on Christmas Island, those that were locked up in detention on Nauru and Manus Island, were something that people were passionate about and they wanted to talk to me about. My first stop on my ride out of Melbourne was at Bacchus Marsh, and I met with some Burmese refugees who had been accepted as permanent residents. They were very fortunate compared to the more recent arrivals. They were working now as part of a social enterprise and were contributing to the country. They were growing vegetables. They were doing that with the support of the local church community and a local person who had donated land on the fertile river flats of the Werribee River at Bacchus Marsh to be helping this group of refugees, largely Burmese but also from other parts of the country. They were showing that Australians do have heart. They were contributing to part of the community and were really wanting and establishing their roots there. And I think the fact that they were growing vegetables on the bank of the river was showing that here they were establishing their roots, they had their kids going to local schools, and they were well on their way to becoming productive, happy Australians like the rest of us. With Australia as a culture, as a country, we have got people from all over the world, and our culture is based on the contributions from people all over the world, so many of them refugees. Our culture is based, as our national anthem says, our boundless plains to share, of accepting people and knowing that they can contribute to our diverse, multicultural country. This is the sort of approach, this is the sort of culture that is being so compromised and so attacked by this cruel and heartless legislation. From Bacchus Marsh, I moved on and was in Ballarat, and I was very fortunate to be in Ballarat at the launch of World Refugee Week, where I met with refugees from Sri Lanka and from Sierra Leone. I met with a young man from Africa who was now the Young Citizen of the Year in Ballarat. He had arrived from war-torn Africa, and he was here again, was now able to contribute to Australia. The Sri Lankan refugees, they were in a more difficult situation. I met with a number of them who were on bridging visas at that stage, and they wanted to talk to me about how we could help them, because all they wanted to do was to settle down and to help and to be part of an Australia and to be contributing to a vibrant, prosperous, healthy Australia and recognising the contributions that they were able to make. And they told me their stories, and that's the really sobering thing for me and for us here who all have got the opportunity to be living good lives, what these people have escaped from. The refugees that we are talking about are people who, through no fault of their own, are suffering. They have suffered torture, they have seen the death, they have seen the murder in many instances of friends, family, of people around them, and they have taken any opportunity, as you and I would, to flee for their lives. And I think putting ourselves in these people's shoes and say, if it's a choice of being shot or it's a choice of taking any opportunity to escape, taking any opportunity to save your children, to give your children the opportunity of a good life, you would take it. And that's the choice that people have been put in, and that's by, regardless of whatever way they can come to Australia, that they have tried to come here. I moved on my journey to Canberra from Ballarat and moved to Shepparton, where in Shepparton I met a group of approximately 60 Hazara men. I was working with the local Hazara community, and I'd said I was interested in meeting some of the local Hazara community living in regional areas, and offered to meet with them. And I expected that we would have around perhaps a dozen men and women that might like to meet with me. I arrived at the community hall that the meeting had been arranged in, and there were 60 of these Hazara men there, wanting to talk to me, to tell me their stories, and to see whether I could help them. Most of these men were on bridging visas. They didn't have the opportunity to work or study, and they didn't have the opportunity to bring their family out, who they knew was still in very dire circumstances in their home countries of Iraq, Iran, Afghanistan. All they wanted was the opportunity to contribute. All they wanted was the opportunity to be able to settle down and to work, to raise their families, and to know that they had the certainty of being able to be Australian residents permanently. They, like many other refugees before them, the expectation would be that once, if things calm down in Afghanistan, as we all hope that one day they may, that they would be able to move backwards and forwards, but still be able to come back to Australia and to see themselves as citizens, global citizens, moving backwards and forwards, as is the case in our modern society. But no, the circumstances they are in, and the circumstances that they will continue to be in, even if they are offered one of these temporary protection visas, is not having that ability, not having the rights that they deserve, not having the rights that we should be able to offer people because of what they can contribute to Australia, and to be offering them safety and refuge. And then finally, the next group of refugees that I met was when I was in Albury-Wodonga. And there was some members of the African community there, but I also met with the Albury-Wodonga community group that was working with them, welcoming them to their community and supporting them as being part of the community. And meeting that group of people really gave me heart, because here, like all over Australia, you had people in rural Australia who were reaching out. They recognised the contributions that refugees from all over the world were able to make to their community, and they were welcoming them into their community. They wanted them to have the same rights, the same opportunities as other Australians. And that's what this cruel, very cruel bill is not going to give people, those opportunities. If passed, this bill is going to widen the Immigration Minister's powers, it's going to marginalise international law and the rules of natural justice, and it's going to severely restrict the ability of Australian courts to scrutinise the government's treatment of asylum seekers. The title of this bill, that I referred to at the beginning, the complex legalese, refers to the legacy caseload. And that's the 30,000 people, including the Hazara men I met in Shepparton, who have sought Australia's protection between August 2012 and December 2013, who have suffered the physical and mental anguish of mandatory detention, of family separation, absolute uncertainty about their legal status and the constant risk of removal to Nauru and Manus Island. And again, referring to the people that I have met, the people that I have known who are in this circumstance, I can attest to that mental anguish, the depression that they feel because of just not having the certainty of knowing whether they're going to be able to stay, and not being able to sleep at night, not being able to know what their future holds. And the whole concept of only giving people temporary protection just feeds into that, when we as a country are better than that. We can be giving these people permanent protection. It's good for refugees, and it's good for us as Australians. To quote the New South Wales Bar Association, this bill goes far beyond what's necessary to deal with legacy caseload. It involves serious departures from Australia's international obligations, both to human rights and more generally. And to the extent that the bill does deal with the legacy caseload, it does so in a way which is procedurally unfair and unjust. And this is a piece of legislation that is the process for us considering this legislation today is just being so inappropriate given the severity of this legislation. And the significance of the changes proposed in this bill should not be understated. Along with the other bills before Parliament, this bill constitutes the single biggest change to Australia's asylum seeker policy ever made, and it is being rammed through here on this last day of sitting today, rammed through on the basis of a blackmail deal to say that you bring this bill, you support this bill, and that 500 children will be able to leave Christmas Island. This is not good process. It is not good lawmaking. It's not the sort of process that when I joined the Senate that I thought I would be part of. The bill's 6 schedules will fundamentally change the way that protection claims are assessed. It changes the criteria by which a person is found to be owed protection and the nature of that protection provided by Australia to those in genuine need. It also changes the legal status of those seeking our protection and empowers a range of government agencies to restrict or remove their liberty. And in each schedule, the bill removes the rare existing features of the Migration Act which operate to protect the rights and interests of asylum seekers. They haven't got many rights, but it's removing the rights that they've got in favour of a system that departs from international law and the rule of law principles. That's one of the very sad things about this, that in terms of Australia's contribution as being a global citizen, really living up to international law, we are departing from that and sending ourselves down a very, very sorry slope. Australia is better than that, and most Australians consider that that's not the direction for Australia that they want to see us taking. This bill is going to have a really ruthless impact on the lives, health and well-being of the 30,000 men, women and children that it's going to be subject to. We have already talked, other Green speakers, including Senator Hanson-Young, have talked of the brutal changes being proposed in Schedule 6, which are going to chillingly classify children born in Australia to asylum seeker parents by the deliberately depersonalising an Orwellian term of unauthorised maritime arrivals, and leave these babies stateless, leave these children stateless. These are children like yours, like mine. These children, they're beginnings of their lives. They're going to have such handicaps to overcome when we could be offering these children, these babies, a good life here in Australia. They could be kids like the kids that my children went to school with from all over the world, that we know that we're offering them security, support and the ability to contribute to the Australian society. And then, once these stateless babies, these unauthorised maritime arrivals, have been declared that way, they're then required to be detained and transferred to Nauru. We've seen what's the circumstances in Nauru. We've seen the cruel treatment of asylum seekers on Nauru. And we'll continue, this government's going to continue to hold children in those cruel, heartless circumstances that we know are going to have long-term impacts and long-term implications on the mental health of the children and the adults who are living there. This bill also astoundingly removes references to the Refugees Convention from the Migration Act and replaces them with the government's own interpretation of the convention. So these changes, which are purporting to allow they're allowing Australia to turn its back on the document that 145 nations have signed up to as a legal framework for the international protection of refugees. These measures have been condemned by the United Nations High Commission for Refugees and the Parliamentary Joint Committee on Human Rights as contrary to international law. They allow the minister to decide the definition of what is a refugee, and there is no review of that that's going to be allowed. This is not good law. And this go-it-alone approach has implications for any attempt Australia might make in future to engage the countries of our region in cooperating to address issues around processing and resettling asylum seekers. How can we possibly persuade other countries to fulfil their international obligations when our own actions show that we are prepared to manipulate and undermine an important international convention? Our hypocrisy will be seen for what it is. As I've already discussed, the bill's going to be introducing temporary protection visas and the safe haven enterprise visas. These visas only last for 3 or 4 years. They limit family reunion, and they require people who are found to be genuine refugees, people who have arrived genuinely seeking protection because of persecution. They are having to continually establish their internationally recognised right to protection just because of the way they entered Australia. As Save the Children has explained, TPVs will mean people fleeing persecution are left in limbo, forced to prove and reprove that they are refugees. The emotional and mental cost of such uncertainty is enormous and well documented. And again, it doesn't have to be this way. It is a choice of this parliament, if it ends up this bill being supported, to make it that way. The reintroduction of these visas is being pursued in the face of a significant body of medical evidence which shows the detrimental effects that TPVs have on people's mental health, and in blatant disregard of the actual facts. They are a hateful, punitive thing. The policy settings that existed the last time that TPVs were introduced have fundamentally changed. None of the deterrence-based arguments apply anymore. We do not need temporary protection visas. And this is because TPVs cannot possibly be seen as a deterrent to the 30,000 asylum seekers already in Australia, whose only other options are to return to a place of harm or face indefinite detention. And nor can TPVs be considered a deterrent to any future asylum seekers arriving by boat, because if they are intercepted, they must be removed to Nauru or Manus Island and will never be offered a TPV. This bill also removes fundamental procedural rights to safeguard the integrity of what can be a life or death decision about a person's need for protection. It does this by introducing a new fast-track procedure and by establishing the Immigration Assessment Authority to deal with the claims of asylum seekers who have arrived by sea in Australia without visas on or after the 13th of August 2012. And this fast-track process only gives asylum seekers one go at setting out the evidence needed to substantiate their protection claim to an immigration official, and it doesn't provide them with any access to independent advice or support. It flies in the face as what is recognised as good procedural and good legal practice. And so, for example, a woman who is fleeing politically motivated sexual violence, for example, will be required to assemble evidence to substantiate her claim without any expert help or support, and she'll only have limited time to do this. We are better than this. This isn't the rule of law that we should be having in an advanced, caring country like Australia. And to make things worse, under the fast-track process, applicants for protection visas will no longer be entitled to have the merits of their claim reviewed by the Refugee Review Tribunal. And in some cases, but not all, they may be able to have a negative decision fast-tracked by the Immigration Assessment Authority, but that review won't involve a hearing where the applicant can set out his or her claim for protection. And the decision will have to be made purely on the papers. They won't be interviewed or have the opportunity to comment on an application, and the applicant will not be allowed to provide new information or evidence except where exceptional circumstances exist. This is extraordinarily bad and it's undermining the whole nature of what it means to be a caring country and a caring Australia, and an Australia that has international obligations, an Australia that really says that we, consistent with the obligations that when we signed up to the Refugee Convention all those years ago, that we said that we were going to comply with. It's not the Australia that I want to live in, and I know it's not the Australia that thousands and thousands of people who have spoken to us want to live in. It's something that really needs to be rejected.
Has expired. Senator Lyons was on her feet first.
Thank you, Acting Deputy President. I call your attention to the state of the chamber.
Is the Senator... quorum is not present, is that your observation? Quorum not present. Ring the bells for 4 minutes. Oh, till quorum's formed. We'll wait till quorum is present. Somebody seeking the call? Senator Gallagher.
Thank you, Madam Acting Deputy President. I rise to make a contribution on the Migration and Maritime Powers Legislation Amendment, resolving the Asylum Legacy Caseload Bill 2014. And Mr Acting Deputy President, I think it's really important to note at the outset that Australia has an enviable reputation in respect to migration matters, and we have accepted thousands of refugees over the history of our great country. And the fact that it is so political now, the fact that our migration policy is so political, is something that I personally deeply regret. But to go to the detail of this bill that's before us, I think it's very pertinent to go through and place on the record exactly what is before the Senate. Schedule 1 relates to turnbacks and addresses issues that have been raised in the current High Court case, CPCF versus the Minister for Immigration and Border Protection and another. relating to the 157 asylum seekers intercepted on the 27th of June 2014. And most of the provisions relate to the operations of Section 69 and 72 of the Maritime Powers Act 2013, the Maritime Powers Act. Section 69 and 72. These sections relate to the detention of a vessel by a maritime officer and the taking of a vessel, Section 69, and the people on it, Section 72, to a destination. This makes clear that the powers exist where the people and or the vessel is being taken away from Australia. It also makes clear that the powers relate separately to the vessel and the people on board, thus covering the circumstance where persons are removed from the vessel. Now, I can tell you, Mr Acting Deputy President, I had the privilege of leading a delegation to ASEAN, and in that delegation we went to Indonesia, and it was very clear through the interaction with members of the Indonesian Parliament that there was concern about turning vehicles back, and they were raised in discussions with our delegation. And it's also very clear that the new President of Indonesia, Jokowi, has also indicated a very keen interest in our policies in this respect. And I'm sure that all Australian governments want good relations with Indonesia. Absolutely sure of that. And I'm sure that we need to deal in a very sensitive and proper way. And this legislation is very, very clear about what it's trying to do, but I just thought I would put that on the record, Mr Acting Deputy President. Now, the ministerial power to give specific and general directions. This bill explicitly gives the power to the minister to give specific and general directions about the exercise of powers under subsection 69 and 71, which can include matters on board an Australian vessel, and 72 of the Maritime Powers Act. This overcomes a concern that a commanding officer's decisions are invalid by the virtue of their discretion having been fettered by the dictation of a minister. These are significant issues which really do need to be on the public record. Maritime powers on the high seas. This bill ensures that the full suite of maritime powers under the Maritime Powers Act can be exercised between Australia and another country, provided the minister has authorised this use and there is continuity with a detainment which has occurred within Australia's contiguous zone. It ensures the provisions in the Maritime Powers Act will apply continuously from where a vessel is apprehended in Australia's contiguous zone to wherever the final destination is. Natural justice not to apply to certain aspects of the Maritime Powers Act. The amendments make it clear that natural justice does not apply to the detainment and the movement powers in the Maritime Powers Act. And according to the explanatory memorandum for this bill, the original explanatory memorandum to the Maritime Powers Act acknowledges the unique circumstances in a maritime environment render the provision of natural justice in most circumstances impracticable. So this seeks to give effect to the original intent of the Maritime Powers Act, separating Australian domestic law from international obligations. This amendment ensures that decisions of Australian maritime officers cannot be invalidated because of a failure to take into account international law or laws of another country. Maritime officers' decisions will only be judged by reference to the application of Australian domestic law. No need for an arrangement with another country. These sections provide that a vessel or a person may be taken to a place outside Australia and near another country, whether or not Australia has an agreement or an arrangement with that country concerning the reception of the vessel or persons. That place may be another country. This changes the terminology in the Maritime Powers Act from place to destination, which may or may not be a country and may be outside Australia. Obviously, these amendments are quite complex. I think they require a reasonable amount of time to consider. I think this should be a regular and healthy debate, because Australia can't really afford to get any of these arrangements wrong. We live in a a delicate area, if you like, where we're dealing with neighbours who don't always agree with what Australia's view is. And we live in an area where trade is really important. We live in an area where good relationships need to be built and harmoniously developed. And I think at times we might take a sense of too much importance of how relevant Australia is to the region. We are only 20-odd million people. There's a country north of us with 10 times that population. ASEAN has 600 million people. China has over 1 billion. So I don't think we can afford to sort of, put our finger up at the rest of this region. We need to do these things very, very carefully and do them with a sense of justice and compassion. So we go on. Time of detainment. Currently, Section 87 of the Maritime Powers Act provides for a 28-day time limit for detainment. These provisions insert a notion of reasonableness in respect to the time it takes for such matters as dealing with detained vessels or a detained vessel, making decisions in respect to the final destination and travelling. The reasonable time associated with these matters is not considered to be part of the 28-day time limit. Accordingly, these provisions seek to prevent an argument that there has been false imprisonment on a vessel over an extended time period. This has the effect on regional processing and interaction with the Migration Act 1958. These provisions make clear that powers in the Maritime Powers Act are intended to operate in their own right. Accordingly, the regional processing arrangements that are written in the Migration Act will not limit the operation of these maritime powers. That is, it cannot be argued that regional processing provisions in the Migration Act automatically apply to detained vessels and the persons on those vessels, thus requiring those persons to be placed within the offshore processing system. Exemptions for customs and other vessels from other legislation. These provisions allow customs and other vessels involved in turnback operations to operate without having to comply with certain aspects of the Navigation Act 2012 and the Shipping Registration Act of 1981 and the Marine Domestic Commercial Vessel National Law, the Marine Safety Domestic Commercial National Law. This essentially means that customs and other vessels are put on the same regulatory footing as Navy vessels while participating in turnback operations. The Minister may make a written determination specifying a vessel or a class of vessels to which these exemptions will apply. Exemption from Legislative Instruments Act 2003 and the ADJR Act. These provisions mean that certain determinations made by the Minister in respect to turnback operations cannot be interpreted as legislative instruments and thus subject to tabling or disallowance. The bill exempts decisions in respect to turnback operations from the ADJR Act, bringing the Maritime Powers Act in line with the Migration Act. This means that any legal action will be restricted to judicial review. We remain open to any policy that saves lives at sea. However, we retain significant concerns about the safety at sea of personnel having to conduct turnback operations, as well as the damage this policy is having on our relationships with Indonesia. And as I said earlier, Mr Acting Deputy President, I have personally heard representatives of the Indonesian people in the Indonesian Parliament in front of our ambassador and in front of our delegation to ASEAN express concerns directly about our policy. And I think it's a really important issue given our relationship with Indonesia. We do not support the Honourable Scott Morrison's attempt to make changes to legislation based on guesses about the outcome of a case which is currently before the High Court. The High Court should be allowed to do its job on this matter before any legislative changes are considered. The subject of this legislation is currently before the High Court, so we believe that until that case is properly resolved, it is inappropriate to introduce this legislation. Mr Acting Deputy President, we go to Schedule 2, Temporary Protection Visas and Safe Haven Enterprise Visas. Now, in principle, we're opposed to the temporary protection visas. They establish within the Act that a TPV of a 3-year duration, which will be offered as a protection visa to any person seeking protection who is in Australia in an unauthorised way. Work rights are provided to TPV holders. Access to the safety net is provided to TPV holders. However, it appears that this will not include access to the full suite of resettlement services. The holding of a TPV bars a person from ever holding a permanent visa. There are no rights to family reunion. There are no re-entry rights. We go to permanent protection visa application deemed to be an application for a TPV. Now, once again, we're opposed. This deems an existing application from a permanent protection visa by a person who is in Australia in an unauthorised way to be an application for a TPV. It also provides a general power to deem an application for one kind of visa to be an application for another. Now, Mr Acting Deputy President, until this legislation was brought on in this chamber, a matter of probably an hour ago, I hadn't had time to go through all of the application and detail of what was before us. So I think it is critically important that this debate happen and that we place on the record exactly what I'm advised the situation is. Now, there's a clarification about the application of bars. Now, once again, in principle, we oppose these things. These provisions are consequential to the deeming provisions above and ensure that the application of bars to the making of protection applications is not altered by the deemed change of a permanent protection visa application to a TPV application. Then we have the temporary safe haven enterprise visa. Now, we support with an amendment. This provision establishes by the name of Chev that there is no detail in this package beyond the name. It is envisaged that regulations will be made around March next year, which will describe. Now, the government has publicly stated that a SHEV will be open as an alternative to a TPV, can be applied for by a TPV holder at any time, will be for 5 years, will allow work rights, will not allow rights to family reunion, will not allow re-entry rights, and will require the holder to live in a region which has nominated itself to be a SHEV destination. Will allow access to the safety net, however not settlement packages, although it is imagined that some regions may provide a package, and will enable a holder who has not been the recipient of a safety net for 42 out of 60 months the ability to apply for an onshore visa and thus may ultimately provide for some pathway to a permanent visa. Pending the outcome of the Legal and Constitutional Affairs Committee inquiry and report, we will consider moving an amendment in the Senate to secure an explicit pathway to permanency. So, Mr Acting Deputy President, quite complex proposals. We now go to the TPV and the SHEV consequential provisions, which, once again, in principle, we support. The bill will allow for multiple classes of protection visas, given that is the upshot of creating TPVs and SHEVs. The bill will provide a definition of a protection visa, given that it will now incorporate more than a permanent protection visa. Our supporting these provisions flows from the conditional support of the SHEVs. Now, Labor has had a long-standing position of opposing TPVs. They don't appear to offer the deterrence value and place people in a state of uncertainty. It remains unclear as to whether the SHEV will offer a pathway to permanency. The legislation does little more than name the SHEV. There is no detail in the legislation regarding the criteria or any firm policy around what the requirements will be, apart from the Minister's public comments. Accordingly, there is a real danger that the Palmer United Party has been sold, excuse the pun, a pup. If SHEVs did provide a pathway to permanency, this would be of value. Labor will give further consideration to ensuring that this is the effect of SHEVs through amendments in the Senate. Now we go to Schedule 3, linking the Migration Act 1958 and the Migration Regulations 1994, which in principle, Mr Acting Deputy President, we express support. This schedule creates an express link between the way certain classes of visas are described in the Act and in the regulations. These visas are Special Category Visas S32, Bridging Visas S37, Temporary Safe Haven Visas S37A, Maritime Crew Visas S38B, and Protection Visas including TPVs and SHEV Section 35A. This clarifies the need to meet requirements for a valid visa application both in the Act and in the regulations, as opposed to the Act or the regulations. If the regulations do not describe any criteria, then the visa will be inoperative. Basically, this is a sensible tidying up of the Act and the regulations. Schedule 4 goes to limiting appeal rights in the refugee assessment process, and in principle we're in opposition to it. For persons who are in Australia in an authorised way, a new fast-track assessment process will be developed. This will involve shortening the existing time frames through regulations which are yet to be developed. Access to the RRT will be removed. The bill establishes the IAA will sit within the RRT. Any adverse initial decision must be referred to the IAA for review. The review will be limited and need only to be done on the basis of the papers, while the applicant can be interviewed if the IAA wishes. The IAA will be able to seek new information if it wishes and consider new information presented to it in exceptional circumstances. The bill sets out the manner in which the IAA will operate and empowers the principal member of the RRT to issue practice directions and guidance decisions. The reviewers within the IAA will be employed under the Public Service Act 1999. There will be a senior reviewer who will have administrative responsibilities as delegated by the principal member of the RRT. So, Mr Acting Deputy President, in the short time that was allotted to me today, I've gone through some really interesting points, and I think a really careful consideration is required.
Thank you, Senator Gallagher. Is it okay? Senator Milne, thank you. Sorry, there was confusion there, Senator Milne. Senator Rhiannon was also on her feet, but I'll give you the call, Senator Milne.
No, it's okay. Oh, okay. Sorry. Thank you very much, Mr Acting Deputy President. Well, on the 5th of April 2013, the Prime Minister, now the Prime Minister, he was opposition leader at the time, Tony Abbott, in a speech to the IPA, his favourite organisation, the Institute of Public Affairs, it's the Rupert Murdoch, Gina Rinehart think tank. He had to say this: "Do unto others as you would have them do unto you is the foundation of our justice. Love your neighbour as you love yourself is the foundation of our mercy." That was our Prime Minister when he was Leader of the Opposition. And now this government is engaged in what I think will be regarded as crimes against humanity, because it is systematic abuse. It is not one-off, not by any means. It is systematic, deliberate humiliation, degradation of people, and a deliberate and systemic process to destroy people's mental health. And that is what this government has undertaken and continued, and that is what we are talking about here today. The fact that there are children locked up in detention at all is a disgrace, and the minister has the power right now to free all of those children and their families. But he won't do it, Mr Acting Deputy President. He won't do it because he wants to treat those children as pawns in a political game to try to get more power and more disgraceful legislation through this parliament. Now, what sort of a person, Mr Acting Deputy President, what sort of a person uses the fact that he has the power to keep children locked up behind barbed wire in detention centres and decides to trade or not trade their freedom depending on whether he can get other people to agree to give him more powers which are against international law? We would be the first as a nation to condemn other countries behaving in such a way. But here we are, Australia, doing it ourselves. There is a campaign that has started around the country saying, Australia, we're better than this. And we are better than this as a country. And as you well know, Mr Acting Deputy President, under crimes against humanity, they are defined as odious offences, constituting a serious attack on human dignity and grave humiliation or degradation of human beings. And people can be held personally responsible for these crimes, and governments, and the threshold, as I said, is that if it's systemic. And so people who vote for these things need to recognise that this is more than just a political debate in the Australian Parliament. This is more than the Australian Parliament making a law. The Australian Parliament and people who make these laws will be held to account and should be held to account. I want to start with, there are so many things wrong with this legislation, it's hard to know where to begin. But the fact that Schedule 6 has in it that you can classify children born in Australia to asylum seeker parents as unauthorised maritime arrivals. No, they are not. They are babies born in Australia on Australian soil, and they should be regarded in the same way as any other child born here and given their citizenship, their statehood. But we are taking their statehood away from them. We are leaving them as stateless people. Now, what do you call this for treatment of pregnant women? There are 2 women, 8 months pregnant on Nauru, and they had been classified as genuine refugees. They had been settled refugees on Nauru. Settled refugees, not criminals, settled refugees. But because Australia has determined to send people to Nauru where clearly the medical facilities are not good enough, and they had to be sent to Australia to have their babies, they have been put in detention. 8 months pregnant, put in detention when they are settled refugees. Well, I call that disgraceful and grave humiliation of those people, and it's degradation of their human rights. They're settled refugees. They should be treated with the respect that they deserve, not shoved into detention. And the children are already in detention. We have had endless reports of the mental health stress of those children. They should be freed immediately. But to come in here and put up a piece of legislation that says, oh well, if you want those children to be freed, you agree to this other appalling set of provisions. And I want to go through some of those. I want to talk first of all about the minister's grab for power, that is the removal of judicial oversight of the use of maritime powers. The fact that this bill will amend the Maritime Powers Act and remove judicial scrutiny of whether Australia complies with certain human rights obligations by removing a role for judges and removing a role for the courts to invalidate government actions at sea proves and provides that the rules of natural justice are not or do not apply to certain key actions, and it suspends Australia's international obligations in the context of powers exercised under the Maritime Powers Act. This is the Parliament saying that it will exempt itself, its behaviour, from the courts, from the scrutiny of the courts. I mean, this is absolutely shocking behaviour in international law terms. We're abrogating our responsibilities under international law, just so this minister can do what he likes on behalf of his government and every one of his ministers and every one of the crossbenchers who votes for this is voting for Australia to exempt itself from the provisions of international law for the sole purposes of the minister being able to do what he likes on the high seas. And why? Because the courts are catching up with him. That's why, Mr Acting Deputy President, the courts, the High Court is catching up with the behaviour of this government. So what do? Exempt themselves from the scrutiny of the courts. What a disgraceful behaviour from a government. But I want to go back to what this bill is also doing in relation to bringing in again temporary protection visas. 30,000 people have already sought Australia's protection between August 2012 and December 2013. They've already suffered. Physically and mentally, they've been locked up in mandatory detention, separated from their families, uncertain about their legal status and at constant risk of removal to Nauru or Manus Island. And on Manus Island, of course, they know that Reza Barati was murdered. And nobody has been held to account for that murder on Manus Island. And this government has tried to palm off responsibility to so-called service providers. Well, the responsibility lies firmly and squarely with the Australian government for whatever happens to people on Manus Island or in the detention centres in Nauru. Now, what this does is go way beyond the legacy caseload suggestion that the government has put here. It's a serious departure from Australia's international obligations under human rights, and it is procedurally unfair and unjust. And basically, this bill changes the criteria by which a person is found to be owed protection and the nature of the protection provided by Australia to those in genuine need. And it changes the legal status of those seeking our protection and empowers a range of government agencies to restrict or remove their liberty. I cannot believe that we are in this situation. You know, I have looked around the world in the past and I've asked myself the question, how is it that decent people who care about other people have allowed the atrocities that go on around them and have just carried on with their lives as if it wasn't happening? And I've never understood how it could happen. And now I'm standing in a parliament where it is happening, where people will happily go home for Christmas and sit up with their own families and make speeches saying, "Do unto others as you'd have them do unto you," make speeches saying, "Love your neighbours as you love yourself," and happily lock up people in detention, exclude Australian government actions from the courts, leave thousands of people in the mental anguish of never being able to settle in this country and wondering what on earth will ever happen to them in the future, happily go off, head off to church, talk about their Christianity, and yet fundamental Christian principles, fundamental decency, fundamental principles of humanity are being violated here knowingly and willfully. Because I also want to put on the record that whilst people will argue that they have no personal responsibility for the crimes that are going to be carried out as a result of this legislation passing, yes, they do. They can't say they didn't know. They can't say it wasn't willful, and they can't use any other excuse. Willfully and knowingly passing this legislation means that you are signing up to crimes against humanity, and it is in the Australian Parliament that people are doing it. And the rest of the world is going to be horrified when they look and see the detail of what it is that Australia is doing to people. I just find it extraordinary. As Save the Children has explained, temporary protection visas will mean people fleeing persecution are left in limbo, forced to prove and reprove they are refugees. The emotional and mental cost of such uncertainty is enormous and well documented. There is a body of significance of medical evidence which just shows the incredible detrimental effects on people's mental health. It is just disgraceful that this is being allowed to happen and that people are going to stand up and vote for it. But the other thing that's appalling is that it's allowing for fast tracking to occur. And to make things worse, under this fast track process, applicants for protection visas will no longer be entitled to have the merits of their claim reviewed by the Refugee Review Tribunal. In some cases, but not all, they will be able to have their case looked at by the Immigration Assessment Authority, but it won't involve any hearings where the applicant can set out their claims, and they will make a decision purely on the papers. And of course everybody knows that for refugees, for people seeking asylum, that is going to be virtually impossible because many of them are already frightened of the authorities because of the way that they've had to leave the countries they've been in. They will have no papers, no one to be able to justify in many cases or prove or verify some of the things that they are saying. This is setting up a grossly unfair procedural process. And you're doing it. You're knowingly doing it. You know, it is beyond my understanding of how you continue to use this Orwellian language. Unauthorised maritime arrival. No. Person. People. People like you and I. People with parents, with children, with brothers and sisters and families and hopes for a better future. People who've had to leave. People who've had to leave Afghanistan. Hazaras who've had to leave because they're being persecuted, and this government thinks it's fine to just turn them around at sea and send them back. Send them back to Sri Lanka, for example, where you know and I know that the Rajapaksa government is engaged in crimes against humanity all the time, and yet you appease them. You appease the Rajapaksas. You know exactly what they're doing in Sri Lanka. You know what they're doing to the Tamils. You know that the white vans turn up and people disappear, and yet you send them back because it suits you to do so, and what's more, give to the Rajapaksa regime some of the vessels which will better enable them to intercept people leaving or to return them. You are more than happy to turn people around, traumatise the Navy, for example. Traumatised the Navy, as we saw on the 7:30 report this week, where people were horrified about what they've been expected to do, and they've been given no counselling or assistance because they are experiencing the humanity that they feel about seeing all of these people in the way that they are being treated. And the fact that anyone could say it would be inconvenient for a refugee vessel to turn up on Australia Day, so let's actually make sure that doesn't happen. Let's turn them around, let's push them back, let's do what we like, let's get rid of them because they're unauthorised maritime arrivals. No, they are people. No, they are people, and they are people of whom the Prime Minister has said, "Do unto others as you would have them do unto you." And it is very clear that he doesn't believe that. He wouldn't have his own family treated in this way. He wouldn't have a child of his own family left stateless. Every child has a right to a name and a nationality, a statehood. Every child in the UN Convention on the Rights of the Child, every child has the right to a name and a nationality. And yet you are taking that away from them. You are saying that child will be stateless, and what's more, we're not even calling a child a child. We're just going to label them in Orwellian terms an unauthorised maritime arrival. Well, international law will catch up with this government. The International Criminal Court was set up to look at systemic abuse by governments around the world, and this government will be and is in breach of international law, and everyone who votes for this legislation knowingly and wilfully supports breaches of international law and will be subject to the same scrutiny as they deserve to be in international law terms. So you can walk out of this parliament and think you've gotten away with it, think you've pulled some great stunt, and in another 20 years, of course, we will have the apology and people will tell their children that they had nothing to do with it, that they couldn't possibly have known. If they had known, that certainly wouldn't have happened. Well, they do know, and they are knowing, and they have done it, and they are making children stateless. They are making people live in limbo on temporary protection visas with no hope for the future and deliberately imposing mental health problems on a group of people. And they are deliberately exempting the Australian government from the law to enable the minister to do as he likes on the high seas. That is a disgrace. And I know that this government will rush out there and say, "Oh, we were doing it to free the children before Christmas." Well, A Christmas Story has in fact Mary trying to get to the inn, you might remember, Mr Acting Deputy President, but the inn was closed, and that's why she ended up in a stable. Well, this lot are the innkeepers closing the door. So when you tell your Christmas stories, I hope you will explain to your own families that you are the innkeeper, you are closing the door. You are sending refugee women who are pregnant into detention, even though they are refugees. Settled refugees is the term. So let's actually have on the record here what this government is doing, and let's not have this being said, "Oh, we had to get the children out." The minister has the power to get them out immediately. The minister has the power not to put them into detention in the first place. They should never have gone into detention. They are being illegally held in detention. It is not illegal to seek asylum. It is wrong that they are being locked up and their freedom deliberately taken from them. This is appalling legislation. It is un-Australian. It is a matter of shame to me that this parliament will pass this legislation, but the future will ensure that justice will be done.
Senator Ludwig.
Deputy President, I rise to speak on the Migration and Maritime Powers legislation amendment resolving the Asylum Legacy Caseload Bill 2014. Can I start by outlining the provisions of this omnibus bill? In this instance, the government, I think, has tried to bring everything possible together on potentially the last day of Parliament and try to deal with what is quite complex matters. Nonetheless, what this bill does do is provide additional powers in relation to turning back votes. The question then arises in my mind, of course, is if they need additional powers, what is the justification for those additional powers? Have they provided an open and frank case for the justification of those powers to the Australian people and to here in this parliament? It is when you juxtapose that with the secrecy surrounding the Operation Sovereign Borders, you then don't get an insight into the justification. You don't get an insight into how they have managed Operation Sovereign Borders. You do not get an insight into where the failings might be which require this legislation. You do not get an insight into how this legislation, this bill will fit in with the current workings of Operation Sovereign Borders. You do not get an insight into how Operation Sovereign Borders has advised, if at all, government that they do require an additional power, they do require some assistance. You do not get any of that from this government. It is extremely disappointing to find that you have a government that's clothed in secrecy when it comes to Operation Sovereign Borders, and I respect the military operation that it is. But let's not then say and continuously say that it is all operations and this should not, and parts of it should not be made available as to how it operates for the Australian public to assess, particularly now when the government has had some time, or water under the bridge we could say, to consider the operation, to consider how it's operated. I've got no doubt they've received reports from Operation Sovereign Borders about how it works. Otherwise, why would we be here with an omnibus bill? So if they do exist, this government should have been more upfront about it and provided the parliament with that material. But I guess we'll get an opportunity, and we may see, in the committee stage to see if the minister might want to add anything to that. But let me say in advance, I doubt very much the minister will add much to this debate today. This is a government that prefers the dark corner than light. It is an area where, if you look at the next part which they seek to introduce temporary protection visas and introduce an alternative new class of visa known as a safe haven enterprise visa. Despite, of course, the minister's comments that no one will receive a permanent visa, it does appear that the, however we want to abbreviate it, may offer a pathway. But we can explore that in the committee stage as to how that might actually work. One of the concerns that, of course, reminds me so vividly about not this government, but a government very, very similar to this one. Perhaps they were perhaps not as shambolic as this one. Perhaps they were also a little bit more coherent. They probably were, in some respects, an adult government, unlike this one, where they implemented temporary protection visas, and it was disastrous. It did not work then, and it's questionable as to whether it will work now. But of course, it is an area where, of course, this government should have looked at what occurred with the previous Howard government as to how it would play out in the longer term. But I guess this government is very short-termism. If you look at their policies that they try to implement, they are, by their very nature, short-termism. The third area which this bill seeks to deal with is to provide a better consistency between the Migration Act and the migration regulations in respect of certain visa types, Schedule 3. I'll come back to that should I have time, but I'll probably get extra time in the committee stage to explore it a little bit further, I suspect. It also seeks to introduce a fast-track assessment process for protection claims, combined with a limited form of review through the newly established Immigration Assessment Authority, removing access to the Refugee Review Tribunal for people who are in Australia in an unauthorised way, which is Schedule 4. It also seeks to clarify the exercise of the removal power and codifies Australia's interpretation of its protection obligations under the Refugee Convention. It also makes clear that the children of unauthorised maritime arrivals inherit the migration status of their parents, Schedule 6, and it also ensures the Minister can cap classes of protection visas in the humanitarian program, Schedule 7. Before I go to some of those more detailed provisions, though, I wanted to go to really an overarching issue which has been concerning me deeply when you look at the overall context of the Omnibus Bill. And that is, I'm not convinced the government could fairly and evenly have a statement of compatibility with human rights in respect of this bill. I have had an opportunity of looking at the provisions within this bill, and you find that they do sign a statement of compatibility with human rights at page 219 of the explanatory memorandum to the bill. I just fail to see how this bill overall allows this government, without exception, without qualification, to sign a compatibility of human rights. The government obviously considers that the bill and regulations amendments are compatible with human rights because they make, which is what this government tends to do, broad sweeping statements about this issue rather than delve into the detail, because it's not a government for detail, it's a government that has a broad brush approach and doesn't care much about the consequences or the detail. When you look at the Parliamentary Joint Committee on Human Rights, you do hope that they will see the implications that this bill has for human rights. Arguably, the most significant and with potentially the most dire consequences would be Australia's non-refoulement, a non-return. It is an obligation that in this bill, the human rights statement and the human rights lawyers should look very, very closely at with this government, because it is a fundamental principle that we have signed up to for a very, very long time. And if you look at the effects of this bill, then the obligation of non-refoulement is a very serious consequence should it be breached by this omnibus. Every government before this one has taken this issue very, very seriously, including, although I may have many criticisms of the Howard government, they took this obligation very seriously. I don't think this government has turned their mind to the detail as well as they could have or should have. And when you look at how we are then having expressed this issue, you do come to the conclusion, I think, that there are serious questions for this government to answer in respect of meeting its international obligations in a way that is both considered and recognising of its obligations. But again, we will have an opportunity in the committee stage to explore that issue a little further. When you then look at the dissenting report of Labor, I think it highlights many of the issues that I have averred to earlier in my speech, which does create some concern. Particularly, and we go more to the broad again, particularly I think Senator Carr used the word balance between the judiciary and the executive. I much prefer the separation between the executive and the judiciary. And there should be and continue to be a separation between the executive and the judiciary. It is not a fine line. I think it's a thick line between what the executive can and should do and what the judiciary can and must do. But in this instance, I do worry whether or not the Maritime Powers has confused, or at least been confused by the government when it comes to the importance of ensuring that there is a separation and that the proper process has been followed. We are concerned about, as I said earlier in my opening remarks, about the secret of on-water operations carried out by the government, and this committee report similarly reflects that concern. Those concerns, though, aren't put to one side or, could I say, assured by Operation Sovereign Border. And you would think, Acting Deputy President, it is within their remit to do that, to tell the Estimates Committee, to tell the various committees that it's been before, that it is an area where they can manage, it is safe to do so, and they can describe some of the examples and they can go through the detail with the various committees that they've appealed before. But they can't. They talk in a very general sense, no detail, no specifics, and the justification from that, I don't think, cuts it today, where we've got an omnibus bill like this being put forward. When you then examine the committee report that gives us the dissenting report by Labor, you also have a government that is, which I talked about, that separation, endeavouring to legislate in areas where they're effectively attempting to preempt the High Court matters. Now, in those areas, it is one where I'm not arguing for the High Court, for either way the case may go. What I worry about is a government that steps in this instance and in a few others in this omnibus bill too often. Too often this government steps into the ring to ensure that they win. I call that not a particularly fair fight, quite frankly. This government may not want a fair fight on immigration because they do tend to want to ensure that they can nobble anybody and everybody they can, or prevent anybody having a view about their process. In terms of temporary protection visas, as I indicated in Schedule 2, the report, the dissenting report of the committee, makes clear that the Labor senators oppose provisions in Schedule 2 which seek to reinstate the failed TPVs. And I did deal with that earlier, so I won't transgress that. I won't deal with that again. The Safe Haven Enterprise Visa, one of those areas where the Labor Party is not standing here saying completely opposition to this bill. If the government had an opportunity of listening, which I think is a difficult chore for them, quite frankly, but should they have listened to the detailed speech given by Senator Carr, they would have detected that there were a range of areas where the Labor Party was prepared to talk to this government about, because there could be in some areas within this bill places which can find a compatibility with a reasonable outcome. A bit unusual for this government. Maybe they've been pushed by the minor parties. It seems to be you only get some decency out of this government where they've had to compromise, be pushed by minor party or pushed by independents to a much better place. I'm not complaining about that. It's not a bad thing, and perhaps Labor has added its shoulder to the wheel to convince this government to find a better place. The point I make about it is this government would not go there if it didn't think it had to. So in the period between 2004 to 2007, it was the government that had the majority in this place, and they didn't bother. They went hard whenever they could. They took the opportunity. They didn't consult. They didn't choose to ameliorate any of their harsh legislation. They treated the Senate like a sausage machine. This government, I think, thought from 1 July onwards they could do the same. They've been rudely awakened that it is not that easy to manage this place. Their easy answer to it all is that it's the opposition's fault, a place for cowards to go and hide and use those phrases, quite frankly. It is your ability as government to manage the program, manage the legislation, manage the debates, and compromise where you have to, consult and compromise. But I think this government has got tin ears when it comes to both consulting and compromising. But not to take away too much. The dissenting report also dealt with a range of other matters, but could I go to one in particular which always concerns me, which I think I outlined a little earlier, was how this government is stepping into what I would always say the preserve of the judiciary. Limiting appeal rights in refugee assessment process, Schedule 4 of the bill, which seeks to deprive asylum seekers the opportunity to have their applications for protection assessed fairly and replaced with a bureaucratic agency subject to the direction of the executive and government. I don't think you can say more than what I just said in respect of that provision. I think it's abhorrent to think that this government considers that an open and fair and transparent process. We all understand that you do need a system that works, but if it is that broken, replacing it with a bureaucratic model such as this disgusts me, quite frankly, because these people, you may not have liked the Refugee Review Tribunal, but my dealing with them and my understanding with them for many years is that they were dedicated to their job. They did it in a well-meaning way, and it's a thankless task. It's a difficult task because sometimes you have to say no, and other times you can say yes, and you may not like either answer to that, but it's a task that's best left to an independent agency or tribunal in this case to do, because I think it detracts from this government. But again, maybe I don't mind the distraction or that position, because I think it ultimately reinforces my view of this government that they do like to have and try to have complete control of the bureaucracy. They do like to have complete control of the outcomes when they fit their purpose, and only when they fit their purpose. And if it doesn't fit their purpose, then they try to change it to ensure that it does. And I think ultimately it is a government that will pay a heavy price for that position. And particularly when you then look at how it is displacing Australia's obligations under the Refugee Convention, as I earlier mentioned, dealing with the human rights issue. I think this government is a poor government.
Thank you, Senator Ludwig. Your time has expired. Senator Rhiannon.
Thank you, Acting Deputy President. This bill should not pass. We've heard some very good contributions in here detailing the horrors that would occur if it becomes law. I do congratulate my colleague Senator Sarah Hanson-Young for the work that she has done over many years on this issue, bringing the voice of refugee advocates, human rights activists into this chamber, representing the rights of refugees in such a clear, articulate way. I also do draw attention to my colleagues in this place and people who read Hansard or listen to the debate to read the speech of Senator Christine Milne, the leader of the Australian Greens. She just made a very telling speech setting out the crimes that really are embodied in this legislation if it goes through, and particularly nailing the issue that there are embodied in this legislation crimes against humanity. We need to realise how incredibly serious this legislation is that we are dealing with tonight. A large number of legal and human rights experts have warned how dangerous the bill will be if it's passed. They do not support the Migration and Maritime Powers legislation amendment resolving the Asylum Legacy Caseload Bill 2014. Just that title, resolving the Asylum Legacy Caseload. This doesn't resolve the caseload. It inflicts cruelty, can result in death, it breaks the law, it should not be passed. Refugees are essentially being used as an electoral football here. We've seen this occur under the Liberal and National parties for years now, where refugees, asylum seekers are demonised, and the issue is played out, particularly coming into elections, where there is such carry-on about the issues of people seeking asylum in this country that people do become fearful. They do start to worry about what's happening with our borders, but it's because of the hysterical, extreme way the people in the government present this issue. Now, I do acknowledge that there have been and are some individual MPs and members of the Liberal and National Party who don't hold the views of the Abbott government. However, we need to acknowledge that when the Liberals and Nationals were in opposition and now in government, they are driving a very ugly policy process here and now pushing forward with laws that will do such deep damage, not just to individuals, but the very fabric of our country itself. The harshness and cruelty of this law is so extreme. If this bill passes, and I understand a deal has been done, and there will be an absolute shift by the Australian government, and senators who are considering voting for this need to recognise what they will be voting for. They will be voting to trash respect for the law, voting to trash recognition of the rights of refugees. Because essentially what this bill will do, if it's passed, will establish in law the mistreatment of asylum seekers and refugees who leave their country where they have faced death, rape, imprisonment, persecution, torture. It will now be very easy to return those people to those terrible threats. This is how far this government is considering going with this legislation. Now, we know it doesn't have to be like this. Many of us here would remember the 1980s and the 1990s, the issue of refugee rights, the issue of asylum seekers on this country barely occupied any space in our media. And that's really worth reflecting on why that was the case. And why it was the case is because there was a bipartisan approach, with Labor and the Coalition at that time actually largely working together for a humane approach to people who have every right to come to this country to seek asylum. And so many refugees were processed quickly and in a way that their safety wasn't in jeopardy and were able to rebuild their lives in Australia. And I did want to share with the Senate tonight some comments by former Prime Minister Mr Fraser made at the 2012 Whitlam Foundation annual speech. And it really does give detail about how this developed, because the period he's describing in the first instance is in the aftermath of the Vietnam War, a war that had been very divisive in Australia, extremely divisive, But despite that, we saw the two major parties at the time, the leaders of those parties, come together with a humane and largely successful approach to handling people who were coming to this country. So these are the words of Mr Fraser. At the end of the Vietnam War, tens upon tens of thousands of Indo-Chinese sought to flee to safety. Initially, the Whitlam government decision was to have limited numbers of people from Vietnam. My government made the decision to take large numbers of people. Gough Whitlam did not play politics with this. It would have been easy to do. Instead, he led his party to fully accept the convention of the post-war years. Bipartisanship on issues of immigration was maintained. The bipartisanship was fundamentally important. It shows that political conflict can live alongside the sustaining of a shared, deep respect for people regardless of colour, race or religion. A belief that people should be respected for who they are. The capacity to engage in conflict and maintain such a respect depends on a degree of consensus between political leaders. Gough Whitlam and I participated in this consensus. If instead of this consensus, the disgraceful race to the bottom of the populist political point scoring of recent years had prevailed, the cost to Australia would have been enormous. Now, I do say that that is the most significant quote, and I urge senators to read all of Mr Fraser's speech. And I did want to just share one other aspect, one other comment that he made in that speech, because it brings us forward to recent times. And Mr Fraser stated, before Tampa, there would have been many who accepted that the idea of the White Australia policy was dead, and that those who supported racism had no influence. Since Tampa, despite the great and beneficial diversity of people within Australia today, there are many who interpret our attitude to refugees and the toxic and demeaning debates that have taken place over this question as a resurgence of racism. They were Mr Fraser's words, resurgence of racism. He went on to say, our treatment of refugees and the poisonous debate engaged in by our major political parties has done Australia much harm throughout our region. Now, this is where we are today. The resurgence of racism, harm done within our own region, and it's actually now beyond that. Mr Fraser's speech was from 2 years ago. We have now got a very bad name around the world because of the way we are treating refugees. It is a shameful period in our history, and if this bill goes through, it will even be much more shameful. The indignity, the abuse, the cruelty of this bill is encompassed in the reintroduction of temporary protection visas. This means that refugees will have to prove and reprove they are refugees. Now just think of our daily lives, our freedom, our rights, the pleasures we take, how we are able to hang out with our families and friends, largely when we wish, when we get out of this place. We can visit our special places. We can work, but for those on temporary protection visas, those basic rights, things that we take for granted, are not there for these people. And let's remember, Australia has tried this before, so we know the cruelty this brings, the anguish, the emotional and mental cost. People not knowing their future, left in limbo, unable to reunite with their family. This is what we are about to impose on people. When the history of our country is written, this period, I think, will shock people when they read back on it. What this country, successive governments, Labor and Coalition, have inflicted on people who have every right under international law to come here. And what will deserve special treatment, and I think will so deeply shock people, is temporary protection visas. This is so ugly. I'm still shocked that I live in a country, obviously with my politics there's a lot that I've disagreed with, but I never thought either side of politics would get to the point where they would treat people like this. So it's understandable people ask what we should do. We should recognise that seeking asylum is a humanitarian issue rather than an issue of border security or defence, and people seeking asylum must be treated with compassion and dignity. I think, again, considering what this bill does, we need to remember that as a signatory to the Refugee Convention, Australia should assess the applications of all asylum seekers who arrive in our territory, including our territorial waters, irrespective of their mode of arrival. And we also need to recognise that Australia has additional responsibilities to refugees from countries where Australian defence personnel have been deployed in conflict situations. Clearly there is a link there, and it is something that we should recognise. We should work to settle people quickly. This is what we need so people can rebuild their lives, gain work, find a home, study, and do all the things that people do have the right to do. Now, the figures themselves show how unnecessary temporary protection visas are. When we had them before, some 95% of people on TP visa first time round ended up with permanent protection. I mean, that speaks volumes. 95% of those people who were put through such humiliating processes have to live under such a degrading way. 95% were given permanent protection, part of our society now. Now, there's no reason to believe this statistic would be any different now. Now, we particularly need to give consideration when we're debating this bill to the role of the minister. He's quite rightly figured strongly in this debate because the bill gives unacceptable power to the immigration minister, and I think we should be asking why. The minister will be really able to make life and death decisions about individual refugee cases. This means the chance of people being sent back to a situation of grave danger, even death, is a real possibility. Imagine this, the bill denies even babies born on Australian soil, in Australia, here, to parents who have arrived by boat any protection. They will be effectively rendered stateless. Again, there's so many aspects of this bill that it shocks you, and then you're shocked again and again and again. They will be tamed offshore. These babies will be retained offshore until they're forced to go to a place like Nauru. The changes to the definition of refugees is one of the most despicable aspects of the bill, and so much flows from this abuse that's set out in the bill. This change means it will be easier. It will be easier to send more people back to where they have come from, where they could be abused, tortured or killed. We don't offer them assistance, we don't offer them protection. We take actions that will lead to harm. The power the minister will have is so troubling. We have the scenario that if the department asserts the refugee can simply modify their behaviour, that's the words, modify their behaviour to avoid persecution or harm at home, then they'll be sent back. What a flimsy policy. I mean, flimsy is too light a word. What an outrageous, cruel policy. Because the people who are making this assessment, they will be either told what they have to do in making those assessments to approve as few refugees as possible, or they will just know that that's what their job really hinges on, to really send by far the majority of people back. That's the situation we're facing. Then there's the issue of travel documents. Now, it's quite understandable that so many asylum seekers arrive with no papers. That's been the case forever with refugees, asylum seekers. That's the nature of escaping from the abuse that they've come to experience. Now, having no travel documents now can be used against them. It can mean, in fact, that they are knocked back. So let's reflect on history here. Let's remember people fleeing from Nazi Germany, fleeing at the end of the Vietnam War, from Pinochet's Chile. All those parts of our history come to mind. And I do believe that so many of those people would have escaped with no papers. But then, at that time, we did the right thing. We assisted those people, assisted them to settle, to rebuild those lives in Australia. And so many of those people have gone on to have wonderful lives here, be a very rich and important part of our society, all those people. But now we don't do that. We do need to ask how many of the people who will come here now will be treated like we've treated people in the past who had every right to come to our country. I fear under Minister Morrison, under the Abbott government, no matter who the minister is, very few people in this situation, similar to those escaping from Pinochet's Chile, from Vietnam post-1975, from Nazi Germany, will be treated in the same way. You come to the point, how extreme does this government want to be? It already have very tough legislation in place. It's already loaded against refugees, and now it wants to be so much more extreme. The current Migration Act has a very tough process to check if asylum seekers should be given protection. Asylum seekers will now, however, have a minimalist process that will determine issues of life and death. Now, some call it the fast-track process, but it's a fast-track process, back for most of them, back to misery. Because it's essentially about accepting minimal numbers of refugees. Consider the state so many people are in when they arrive here. They're frightened, they're intimidated, particularly often intimidated of authority. And who do they have to deal with when they come here? Military people, and I know that many of those military people are absolutely trying to do their best, but put yourself in the mind of these people who are coming here. So often they've fled authority, fled from military people, and then they've got to again adjust to the situation that confronts them when they first arrive. Then they face department representatives who have been told if they have told what the minister expects from them. Like, that is going to be set out very clearly. And again, I repeat, many of them will know, even if it's not told how many they can approve, that that's what the minister wants. That will be the culture. That will be the intent of how this bill will play out for people who have to put it into effect. Asylum seekers will, in the main, have to quickly assemble their case with no legal assistance. That's the other aspect of this. How hard will that be? You're confronted by a new range of authorities, and you've got to try and articulate your case. You may have no travel papers, and you will have no legal assistance. On top of this abusive process, abuse of people, this bill gives the government the power to disregard whether someone is at risk of torture. Can you imagine that? I mean, torture is something that I've often felt in our society, that it's one of those characteristics that one recognises that torture is wrong, that it needs to be, it's a criminal act, and one needs to speak out and highlight what regimes engage in torture and how we need to assist people who escape from that. But here we have a government with the power to disregard whether somebody would be at the risk of torture if they return. I mean, again, it's one of those aspects that I find so hard to believe, that the government wants to make torture effectively irrelevant when it comes to determining the status of asylum seekers. Another horror aspect of this bill is that it is designed to put the government actions above international maritime law. This will allow the minister and future ministers to force people on boats back to the country they have left without any court oversight. Again, a real abusive process and our international obligations under law. I've set out the case, and many of my colleagues have too, in a very thorough way, why this bill should not be passed. I think just to touch on, there is also the very ugly aspect of how so much of this work has been outsourced to a private company, Serco. And that deserves a mention here, because every time the law gets worse in this place, Serco, a private company, makes more profits. And that's now on the record, because this is a British multinational, it's in financial trouble, and significantly the company, which is favoured by governments in other countries as well, and by ours to lock up refugees, has admitted that it's its Australian detention operations that is effectively keeping it afloat. So it's in financial difficulties, and based on cruelty, we now have private companies that are profiting out of the misery of people who our country, our government, our departments should be working with to help them rebuild their lives. This bill should not pass. It will be a shameful day if it does. Thank you, Acting Deputy President.
Thank you, Senator Rhiannon. Senator McEwen.
Thank you, Mr Acting Deputy President. I call your attention to the state of the chamber.
Quorum required. Ring the bells. Quorum is present. Senator McLucas.
Thank you, Mr Acting Deputy President. I also rise to make my comments on the Migration and Maritime Powers Legislation Amendment resolving the Asylum Legacy Caseload Bill of 2014. And Mr Acting Deputy President, at the outset, let me make a few comments about the way that this legislation has come to the chamber. I've got to say that what I saw happen in the chamber this afternoon was some of the worst behaviour we've seen in this place. And when this happens, we are all diminished. We have to be very careful in the delivery of our responsibility as senators, that we ensure that this chamber and this place commands the respect of the Australian people, and that did not happen today. Unfortunately, and that can only be sheeted home to the government. The government is the party that runs this chamber, and the silliness that we had to witness this afternoon does us no good. So I do call on the government to...
Sorry, order, one moment. Point of order, Senator Ruston.
Relevance. I thought we were discussing the migration bills, not behaviour in the chamber.
We are, Senator McLucas. If you could return to the second reading speech for the bill before the chamber.
I think that are you ruling that I'm out of order in speaking in the way?
Well, I'm not ruling you out of order. We do allow some latitude, but a point of order has been raised. The question before the Senate at the moment is the bill, and so I'd ask you to focus on the bill.
Well, to conclude, I do understand that those opposite would find what I'm saying a little they're a bit sensitive, you know, they find it a bit... the criticism that I am making of them will hurt, but it is their responsibility to keep order in this place, and it did not happen today. To go then to the bill has a number of schedules, 7 schedules that Labor senators have very significant concerns about, well, some elements of the bill, and we cannot support it in its current form. And I want to go through some of those schedules and how they will operate, but also why Labor is opposed to them. In Schedule 1, the intention of Schedule 1 is to seek to provide legal authority, according to the government, for the government's policy of turning back asylum seeker boats on the high seas. Now, during this committee inquiry, there was a lot of discussion about this particular element and what its intent in fact is. The intention, as described, is to give some legal authority for the actions that are happening on the high seas. One that we don't know about them, but they're still happening. But the government asserts through Schedule 1 that this requires some sort of legal framework. Labor Party maintains its long-standing concern about what has happened since the change of government in the ocean between ourselves and our northern neighbours. We heard on the government coming to power of Operation Sovereign Borders. It was turned into quite militaristic type of response to the issue of people seeking asylum in Australia, and we had to, according to the government, turn this response into a response that had a militaristic way of behaving. Who can forget those uncomfortable weekly briefings that Minister Morrison was conducting in the early days of this operation? Painful they were, with Minister Morrison refusing to answer any questions almost, saying that they were on water matters, and I request that Hansard put on water in inverted commas. Everything was an on water matter and couldn't be answered because that would compromise the operation. The secrecy that we had in those days, and it's not a lot better, but the secrecy we had then was a shameful part of Australia's history in dealing with migration matters. But the other part of it that offended me particularly was, frankly, the abuse of Defence Force personnel. The fact that Minister Morrison demanded, I can't work out how that happened, but he required a member of our Navy to stand with him to respond to media questions. I think that was a dreadful abuse of our military. To use them as in that way was appalling, and I make no criticism, though, in saying these words of the officer involved. He was doing what the government of the day had asked him to do. That process, as we all know, then moved away from those very awkward weekly briefings to more information, and then finally, and I was pleased about that, the officer, the naval officer, then was not required to stand with Minister Morrison. But I've got to say, we still don't really know. We don't know what is happening out there on the water. We don't find out. We've even had the circumstance where the Immigration Minister has refused to admit that a boat has been intercepted, despite widespread reporting in the media that that is the case. It has gone past amusement. It is now to the point of embarrassment. And as previous speakers have talked about, it is, frankly, the way this is happening, a shame on our nation, and we should behave better as a nation when we're dealing with these matters. It's important to note that in 2012, Admiral Ray Griggs stated before a Senate Estimates inquiry, and I'll quote him, and he said, "There are obviously risks involved in this process," and he was referring to turnback. We are yet to hear, we're yet to find out what is different, what has changed that means that there are no longer risks involved with turning back boats to Indonesia. The other issue is the issue of the relationship with Indonesia. our closest neighbour, a very important neighbour for us, and with the number of incursions that have occurred into Indonesian waters, I find astonishing. We are yet to know why and how this has happened, but importantly, it has now impacted our relationship with Indonesia, and the new Indonesian president, His Excellency Joko Widodo, has issued a very stern warning to Australia about, to the Australian Prime Minister, in fact, about the Australian Prime Minister's failure to respect Indonesian sovereignty. This is a relationship that has to be mended. This is a relationship that we have to make sure is strong and respectful, and to do that it will require good diplomatic relations, but also a continued openness with Indonesia as our nearest neighbour. But I think we should call Schedule 1 for what it actually is. It is not, in our view, well, it is less about legislating for turning back boats, but it is more about seeking to undermine a specific case which is before the High Court, namely CPCF versus the Minister for Immigration and Border Protection, commonly known as the CPCF case. It is our view, it is Labor's view, that this Schedule 1 is a preemptive strike on an existing High Court case, and our view is that it is an inappropriate basis way to legislate. It is important and surely fundamental that the High Court be allowed to do its job and apply the rule of law. So surely that this government can respect the role of the High Court. The High Court should be allowed to determine the legality of the government's turn-back policy as implemented on the basis of existing law. If the policy is shown to be totally lawful, that is important for public confidence in the government and its actions. Equally, though, if aspects of the turn-back policy are found to be unlawful, it is important that this be a transparent part of the public record. This, in my view, is an extraordinary way to use this Parliament and legislation generally, and accordingly Labor senators will oppose Schedule 1. In the time I have available, I do want to go to the visa elements of this bill. This bill proposes to reintroduce into Australia the temporary protection visas. The government argues that this is a deterrent to people coming to our country by boat, but there is no evidence to support that assertion, none at all. When the Howard government introduced TPVs, more than 90% of refugees who were initially granted temporary protection visas under the Howard government, as I said, were eventually granted permanent protection because the situation of their country of origin had not changed. This is not a deterrent, and it is a furphy, frankly, to argue that that's why they're being introduced. The reality of what happens with the introduction of temporary protection visas is that people seeking asylum are placed in a state of limbo. And I'm sure many of us in this place have met people who have been living on temporary protection visas. They are in a place where they cannot make decisions about their lives. There is a level of fear and an anxiety that they will be returned to their country without and putting them into a dangerous circumstance. They live in incredible financial hardship. But it is the effect really on families who are living under temporary protection visas and their ability to make decisions about their futures that I find the most troubling. You see families who've made decisions not to progress with education, not to make decisions about forming families. People are almost put in limbo, and it's a cruel way of dealing with potential migrants. In December last year, when the Parliament rejected Minister Morrison's policy of bringing back temporary protection visas, Mr Morrison reacted by stopping processing people. I've got to say that was a pretty petulant response. Labor believes that the correct response should be now to start and continue processing people without delay and managing our detention facilities in a safe, humane and dignified manner. But the other important point to make is that this deals with people who are already in detention, who arrived before the 19th of July last year. This flies in the face of any argument that this is a deterrent policy. This deals with that group of people who are currently in detention. The other visa class that this bill ostensibly introduces is the Safe Haven Enterprise Visa. This has emerged following consultation with Mr Palmer and his party, and results from those consultations earlier this year in September. But the truth of it is that this bill does not, in fact, give any legal effect to Safe Haven Enterprise visas as a new visa class. The most that the bill actually does is to introduce a new subsection 35A3 into the Migration Act, which provides, and I quote, this is 3A, there is a class of temporary visas to be known as Safe Haven Enterprise visas. But that's it. There are no further details, there are no criteria for the visa or the conditions that apply for it. And I am interested to know whether Mr Palmer and his party are comfortable with the words in the legislation as it stands. Does that in itself deliver on the agreement that was made in September of this year, that where Mr Palmer then provided some support for the bill? It does not, in my view, provide Mr Palmer's the outcome Mr Palmer was looking for when he said that it will be a win for regional Australia, which will benefit from the additional work resources in communities where there is a labour shortage, thereby increasing the viability of these areas. So I am interested to know whether Mr Palmer and his party are comfortable with what they have achieved in negotiations with the government. Does it actually provide what they were seeking? Because the other question that they might want to ask is how many people will be able to receive a SHEV, a Safe Haven Enterprise Visa. Mr Morrison himself responded to a question during a press conference when he was asked how many people would be able to receive a Safe Haven Enterprise Visa, and his answer, when he was asked would it be a very small number, and his words were, it's very possible. It's also a question about there is also a high level of doubt about many aspects of the visa, including what pathways there will be to other visas, an issue that does need some clarification. There is a question about regional Australia, what is the definition of regional Australia when it applies to the Safe Haven Enterprise Visa, and what social services would disqualify a holder of a Safe Haven Enterprise Visa from applying for other visas. We do need some clarity about those elements. If the agreement with Mr Palmer is to be upheld, I think Mr Palmer should be asking for answers to those questions. As I said, Mr President, there are real questions about the way this was introduced into the Parliament, about the decorum and the demeanour of the Parliament during its entry into the chamber. But there are also questions, in my view, about what we should be doing as a country in terms of dealing with asylum seekers as a nation. Repeatedly, people say to me that they are offended by the way that the language has drifted to the bottom, that we use the wrong language to describe asylum seekers. The word illegal is used inappropriately and in a legal sense incorrectly to describe people who are seeking asylum in our country. We are better than this. We can be respectful to people who are acting within the law. We know that we have to work with our international neighbours, with the international community more broadly, to ensure that the very, very large numbers of people who are seeking asylum from their war-torn countries are provided the support that we can give. We are probably the furthest away, possibly than New Zealand, in terms of destinations of people seeking asylum. We can do better. We can do it in an orderly way. We can provide to our community, though, a much more dignified way of speaking about individuals who are seeking asylum in our country. People have talked about bipartisanship. It's hard to say, hard to see where we will be able to get to a point of bipartisanship in the future. But I still do have a hope that we should aim for that we should aim for a place where we do not turn desperate people into political footballs, where we do not use people seeking asylum who come from different nationalities, different religious backgrounds, that we demonise those people for the benefit of a political outcome. It has been, unfortunately, the case for about the last 10 years, maybe even longer, that we have been divided as a nation on this issue. It is time that we do come together to try and provide a better way for our country.
Senator McLucas, your time has expired. Senator Ketter.
Acting Deputy President, and I rise to make a contribution in respect of the Migration and Maritime Powers Legislation Amendment resolving the Asylum Legacy Caseload Bill of 2014. And I rise to make a number of points in respect of the proposed bill, which some have characterised as the most significant piece of legislation which has been put to the Parliament since the election of the Abbott government in respect of immigration and asylum seekers. Of course, this is an omnibus bill, as many of the speakers have already indicated. It contains many parts, and of course there are some parts of this bill which Labor can support, but there are a number of significant concerns which we have in respect to certain aspects of the bill. And I think probably the most appropriate way to characterise my concerns with the bill is that it does not apply principles of fairness and natural justice to the very contentious issue of dealing compassionately with refugees. Labor understands that there does need to be a balanced approach between the fact that we do not want to see deaths at sea, but on the same token we want to deal compassionately with people who are refugees. Labor knows that the contribution that refugees have made to our country over many years, so it's a vexed issue, very contentious, and it's a bill that's broken up into a number of parts, as I indicated. The parts that I've been attempting to deal with are the areas in which Labor has some concerns. But just as a brief overview of the various parts of the bill, Schedule 1 provides additional powers in relation to turning back boats, and I will come back to that particular schedule with some comments. Schedule 2 seeks to introduce to reintroduce temporary protection visas and to introduce an alternative class of visa known as a safe haven enterprise visa. And although, as we will see, this class of visa seems to be introduced in name only, very many parts of that particular visa and how it will operate are left for next year in terms of regulations. So that's an area that I'll make further comment about. Schedule 3 provides better consistency between the Migration Act 1958 and the Migration Regulations of 1994 in respect of certain visa types. Schedule 4 goes on to introduce a fast-track assessment process for protection claims combined with a limited form of review through the newly established Immigration Assessment Authority, removing access to the Refugee Review Tribunal, or the RRT, for people who are in Australia in an unauthorised way. Schedule 5 clarifies the exercise of the removal power and codifies Australia's interpretation of its protection obligations under the Refugee Convention. Schedule 6 makes clear that the children of unauthorised maritime arrivals inherit the immigration status of their parents. And Schedule 7 ensures that the Minister can cap classes of protection visas in the humanitarian program. Now, in terms of Labor's position, we are opposed to Schedule number 1, and in making some comments about our position on Schedule 1, I want to reiterate the Labor position, which is that we are completely committed to doing everything we can to seeing an end to deaths at sea, the human tragedy which is unfolding on our borders. And Labor has a history of attempting to put arrangements in place which deal with this issue. We put in place the Papua New Guinea arrangement, which did a lot of the work necessary to see an end to the flow of asylum seeker vessels. But we do have two concerns about Schedule 1, and I think some of the speakers before me have touched on these points. Firstly is the fact that we do need to do this in a way which does not have a detrimental impact on our relationship with Indonesia. Labor has a very clear history of understanding the diplomatic necessities in that regard, and the incoming President of Indonesia has made some comments in respect of Australia's border protection policies. His Excellency Joko Widodo, in fact, as I understand it, has issued a stern warning to the Australian Prime Minister about his alleged failure to respect Indonesian sovereignty. So we do need to have an approach which is not going to impact our very, very important relationship with our northern neighbour. It's obviously a country with 200 or so million people, and being one of our closest neighbours, it's extremely important that we have a hand-in-glove relationship with Indonesia in respect of dealing with asylum seeker vessels. And that is the approach that Labor adopted in government. In fact, we were able to achieve that close working relationship. And it's really important that over a period of time, it's probable that this is not a short-term issue that we are addressing here. We're probably looking at an issue which will take some years to work its way through. Obviously, the sooner the better, but in order for us to deal with this comprehensively with Indonesia, it's important that those concerns be taken into account. The second concern we have with Schedule 1 is the question of safety at sea. And we have had advice from Navy to the Parliament about the question of safety at sea. And unfortunately, there appears to be a lack of information in respect of this issue. And when there is a lack of information, then there cannot be public confidence in whether or not the operations which are occurring at sea are in fact safe. So it becomes an open question. So in order for us to form a position in respect to the issue of turning back boats at sea, there is this need for further information, and we need to be satisfied that it is a policy which can be carried out safely. And the other